I can't possibly provide you with legal advice in this forum, so it's not offered as such. Think of it as education or attorney advertising, but not legal advice. And with that out of the way, let's talk about the law. There's simply no such thing as an ornamental trademark. There's only ornamental use of a trademark. So trademarks themselves can't be ornamental, but you can use them inappropriately. Trademarks have to be used as source indicators. They have to be used as trademarks. And it can fail to function if you don't use it the right way. So there's a couple of times when this comes up. The first one that people usually run into is when they're applying for a registration with the USPTO and they provide a specimen. The specimen is just a picture of your trademark in use, but it's decorative. The use that they're showing is decorative on the front of a t-shirt or on a mug, something like that. That'll be considered ornamental use, and the specimen will be rejected. Not really a big deal, easy enough to fix. You just need a different specimen, right? That shows it actually functioning as a source indicator. No problem. The other time that it comes up is after you're registered, after you're using your mark. If you're not using your mark as a source indicator, as a trademark, maybe you're only using it decoratively in this context, a competitor can come and petition to have your mark canceled. They can argue that you haven't been using your mark as a mark, and they might be right. So that's a harder thing to deal with. What I recommend is that annually, anyway, you get together with the people that are providing your legal support, and you take a look. How are we using this mark? Are we using it the right way? Is the evidence solid that we're using it as a source indicator? Usually not a problem, but it's something to look at least annually, is what I suggest. A related piece, while I'm on the topic, because it's about how you use your mark, is trademark mutilation. Sounds terrifying, right? But what it means is that the mark you've registered for, you're using it not the way you've registered it, essentially. And I'll give you an example that's based on a real case. Details are a little different, but let's say you make cars, right? You make cars. So you're going to call your car model an RM140, RM140, right? You apply for that mark, you get a registration, things are great. You're going to use that mark as a mark. You're going to put it on the trunk lid on the back, right? That would be trademark use. But instead of having it be RM140, you have RM on one side and 140 on the other side. So now you're not really using it the way that you registered it. You've mutilated your own mark. You may think you're using the trademark, but you're not. You're not really using the trademark. So that's another thing to watch for. That can trip you up. So no such thing as an ornamental trademark. Only a failure to use your trademark as a source indicator by using it in a decorative fashion or an ornamental fashion. It's all your intellectual property. You have more of it than you think, and we'll talk again soon.